Okay, we'll go ahead and get started. Welcome everybody to the first session in our April Lunch and Learn series. Today we are focused on understanding juvenile abuse and neglect court, and we are joined by Judge Francis Martinez, who presides over one of our juvenile abuse and neglect courtrooms. Just a few housekeeping things before we finish up today. I will throw a link in the chat for an evaluation, so please make sure you complete that. Secondly, I think we are hoping this will be an interactive discussion. Judge Martinez is going to walk us through the juvenile abuse and neglect court process. So make sure you have your notepad handy so you can take down all the terms that he's going to explain. But also, if you have questions, Judge Martinez and I talked earlier, and I think he's fine with you asking those along the way. So without any further ado, then I'm going to turn it over to Judge Martinez to take it away. So, Judge.
Good afternoon, everyone. Nice to see everybody here, and I'm happy to participate in this. So I preside in one of the two juvenile courts here in Winnebago County. The other one is presided by Judge Buell. And I was asked to come and discuss what goes on in juvenile court and perhaps give a little bit of background and impart a little bit of knowledge as to what we do on a daily basis here in Winnebago County at the Juvenile Justice Center. So let me start by starting to discuss how cases come into court in the first place. How does something end up, how does a family, I should say, end up in front of me? And there's basically two ways that a court typically comes in. Now, I'm just as a cautionary note, I am excluding one segment, and I may double back to that if we have enough time. But there's a genre of neglect case that I preside over that's specially assigned to me called educational neglect. And those are the kids that are, and that goes along with truancy, but those are the kids whose parents essentially are not getting them to school for one reason or another. And we have kids that are from first grade, second grade, all the way through high school that have significant truancy issues. And those cases come from a different source, the Regional Office of Education. What I'm going to be talking about today are the more typical cases, the more typical cases of what the average person considers abuse and neglect, or considers a juvenile court case, that is, areas of abuse and neglect. So let me start how these cases start. These cases always start with an intervention by the Illinois Department of Children and Family Services into a family. And these interventions generally begin by someone, a citizen, a family member, someone who witnesses some activity. Could be a mandated reporter, could be a reporter that's not mandated, just as I said, a citizen makes a hotline call. I don't have the specific number, but there is a 800 number you can Google. If you suspect that a child is being neglected or abused, or you see something extraordinarily out of the ordinary, you may call this hotline that's manned by DCFS that will take the report, take the facts, and then the matter will be assigned to an investigator. Depending on what the allegation is and what the facts are, or what the reports are supporting it, it may go to a sort of I guess what you would consider an emergency investigator, someone who must respond immediately. For example, if there's an allegation of sexual assault or sexual abuse, that gets an immediate response. If it's an allegation of, a household that unsanitary conditions or something, that might get a response that's not an emergency response. An investigator will eventually come within a reasonably short period of time to find out what's going on. But in any event, so cases start with the intervention of the Department of Children and Family Services pursuant to a hotline call of some sort of abuse or neglect. Upon investigation, upon gathering facts and deciding on what course of action to take, the department essentially offers or has available two roads. The first is if the situation does not rise to a level where the department believes they should remove the children immediately. There's a term we use for that, and it's in the statute. It's called urgent and immediate necessity. If the department does not believe that there is urgent and immediate necessity to remove the children, what they will do is, after pursuant to an investigation, if they, and here's another term I'll define, if they indicate a report, and that's a term of art, if they find in their investigation that there is a credible amount of evidence that indicates that, in fact, the child is a neglected or abused minor under the Juvenile Court Act, they may open what is called an intact case, meaning the family stays intact, the children are not removed, and the family is offered services. If it was domestic violence that drew the attention of the department to the family, there are domestic violence services that are recommended. If it's a substance abuse issue that drew the attention of the department to this family, then substance abuse may be an issue. Or if it's something, whatever drew the attention of the department to this family, and during the investigation, other issues are discovered. So a substance abuse of some sort may draw the attention of the department to this family. And in the course of the investigation, it is discovered that there's a significant amount of domestic violence going on. So the department must decide if they wish to offer what we call intact services, that is, services, this is without court involvement, services to this family to address the conditions that drew the attention of the department. The family, if they accept this, if they accept services and agree to engage in some sort of counseling or treatment or whatever is prescribed, then the matter proceeds outside of court. If the family agrees to engage in the services that are recommended by the department when they investigate whatever drew their attention to this family, if they agree to do so and then fail to do so. So if they say, all right, I will subject myself, or the parents agree to undergo random drug testing, to undergo a substance abuse assessment. And then a few days later, they decide, nope, we're not going to do it. We changed our mind. We refuse services. Well, then the department must make another decision. They must make the decision as to whether they should take protective custody of the children, meaning remove the children from the household because the parents have not agreed to address those conditions, or simply refer the matter to the state's attorney's office without taking protective custody. And then if that happens, then it's the state's attorney's responsibility to decide whether they want to file a petition under the Juvenile Court Act to initiate a juvenile court abuse and neglect case. So that's a state's attorney decision once referred by the department. Now, if it's a case that draws the department's attention to a family and they find that it's a matter of urgent and immediate necessity, that it is urgent that the children be removed immediately for their safety, then they take what we call protective custody. Now, that's a different avenue into court. If the department takes protective custody of a child, that triggers a hearing that must be commenced within 48 hours of protective custody being taken excluding
Sorry.
weekends.
That's okay.
Yes, excluding weekends and holidays. So if protective custody is taken by the department at 4 p.m. in the afternoon on a Tuesday, then what we call a shelter care hearing. A hearing must be held within 48 hours. That would be 4 p.m. on Thursday. And typically those hearings are held in our courtrooms, both Judge Buell and I. Those are typically set for 10 a.m. So the department takes protective custody, immediately sends their information in an informational packet, a statement of facts, titled a document titled Statement of Facts, with all the facts that they have so far discovered. There's possibly more investigation to do, but because of the time limit of 48 hours, sometimes the department only has access to a portion of the information that will eventually uncover. But in any event, if protective custody is taken, the state's attorney's office is notified, and the state's attorney will file a petition, and the matter will be set for 10 a.m. within 48 hours of when protective custody was taken. And the parties will be advised of their date in court if they can be found. Many times, what has happened is, for example, a child is removed when one parent had custody or possession of that child. The other parent is simply not involved in that child's life. A mother or father may be unknown. It may be a single parent situation. And that triggers a number of things that have to be done procedurally in court to obtain jurisdiction over both parties. But typically, the department investigator who's been assigned this case will then advise the parties of the date and time of the shelter care hearing, Thursday, April something, at 10 a.m., courtroom 3 in the Juvenile Justice Center. So that brings us up to the hearing date, the shelter care hearing. Again, the shelter care hearings triggered by the taking of protective custody. There is no time limit, such as the 48-hour time limit, in a case where the children have been left with a parent. So if the department has not taken protective custody, but simply referred the matter to the state's attorney's office for the filing of a petition, I typically set a court date for an arraignment, and a summons is issued to serve the parents with a summons to come to court, and we deal with that situation on that basis. And then the children, of course, unless some intervening event occurs, the children typically stay with the parents as long as the court and the parties feel that the children are still safe. I've just been talking for approximately 12 minutes. Looking at my clock, are there any questions at this point? Have I confused anybody? I'm trying to be as compartmentalizing of these issues as possible. I'm trying to explain terms too, but if there's something that triggers, what the heck's he talking about? I think you can raise your hand or let me know, or feel free just to say something and I will clarify whatever you need. So let's talk about the shelter care hearing. Okay, a hotline call's been made. Some allegations have been made against a caregiver, a parent, two parents. The department has responded. The department has decided that this is a situation that requires protective custody of the children to be taken. And they take protective custody. They notify the parents that they are taking protective custody. The children are taken. One of the things the investigator will do in speaking to the parents is find out, are there any relatives? Are there any friends, close friends, which we call fictive kins. Is there anywhere we can place these children that have some sort of connection to your family? That's DCFS's policy, to go with a family or fictive kin person first. If there is no one, then they will reach out to a traditional foster placement that they have that may be available to take in a child or children. Hopefully we can place, if there's multiple siblings, 2 or more, hopefully they can be placed in the same home so as not to be separated, but sometimes that's frankly not possible. So you might find siblings placed in 2 different foster homes. Hopefully, what we attempt to do is make sure those siblings certainly have a good amount of contact with each other, that we want to make sure they don't lose each other. So sibling visitation is a very high priority in the juvenile court. But in any event, protective custody is taken. The children are placed in a safe environment that's sanctioned by DCFS, and the matter comes to court. When the matter comes to court, then I have parents in front of me. I have a prosecutor. I have the attorney for DCFS legal present, the state's attorney, and I have defense attorneys to assign and appoint to the parents. And a shelter care hearing actually has multiple purposes. The first thing I have to do is arraign the parents, that is, advise them of their rights, and I need to gather some information that's required by law. So typically, when the shelter care hearing is called and parents come in, I start by confirming their address, phone number, contact information, and then we go into the elements of an arraignment. And that starts with advising them of their rights as parents, not as a perpetrator, but as a parent, a caregiver. They have rights in my courtroom. They have the right to be notified when court is. We must give them notice of court. We can't have court without telling them. They have a right to be present. They have a right to an attorney. They have a right to bring witnesses to court if there's a contested matter, and they have a right to challenge witnesses to testify against them if there's a contested matter. So we go over their rights. Then I have to discuss a federal law. There's a federal law that governs us called the Indian Child Welfare Act. The Indian Child Welfare Act was enacted in 1978 to involve Native American children that come into care. So it requires me to ask each parent, are you a member of, or do you believe you would be a member of any Native American Indian tribe that's registered in the United States with the Bureau of Indian Affairs? Most of the time, the answer is no. Sometimes the answer is, well, I think I'm part Native American, but I'm not really sure. Other times, a parent pulls out a card and says, yes, I'm a member of the Cherokee Nation. So if we ascertain facts that are sufficient to trigger the Indian Child Welfare Act, then the state's attorney, after the hearing, the state's attorney must send notice of the act to each tribe. That is because sometimes there's multiple tribes. So someone might say, I believe I'm a member of the Cherokee Nation. Well, there are multiple Cherokee nations, Cherokee tribes that are registered, going back in our history and what occurred in Native American dislocation and movement. So we will send notice to all Cherokee Nation tribes with relevant information of the person, whether they are a member or not, if we have a membership card, or if we believe they're members, or if they just have the name of the ancestor that was a member. The tribe will ascertain if they are, in fact, if they meet their criteria for membership in the tribe, and they'll send a letter back. And if they are if they qualify, if the minor is going to qualify as a member of a Native American tribe, then that Native American tribe has the right to participate and intervene and participate in these proceedings. Or the tribe may send back a letter saying, per our records, no, this person is not or does not qualify for membership. And that ends that inquiry. So most of the time, the parents will just simply say no. And that's all I have to do is ask about that particular issue. So then after discussing ICWA, we have to discuss the paternity, because we have to establish that every person who purports to be a father is in fact the father. So there's several ways of doing this. If a child is born of a marriage, that creates a presumption of paternity that makes the father the legal father. If the father signed the birth certificate, signed a voluntary acknowledgement of paternity, and his name is on the birth certificate, that makes him a legal father. If a father has been subject to other litigation like child support and has been found by a court to be a legal father, then that satisfies paternity. And if all those fail, we can always order DNA to ascertain if that person is the father. And I always tell the father, I always say, I have no doubt you're the father. I don't want them to think we're trying to chase them away. I have no doubt I will treat you as the father. I will treat you with all the rights of a father, but it is our obligation to verify your paternity. And well, you'd be surprised how many times a person's on a birth certificate and DNA is ordered because someone expressed a doubt. You know, we do want to err on the side of caution. So a person's on the birth certificate and then comes back as not the father. This could be a very awkward and difficult situation if that occurs, and it does occur from time to time. Any event, so after discussing paternity, then I move on to the fourth area that I have to discuss with them at this shelter care hearing. So at the shelter care hearing, I have to tell them that the state has filed this petition, which they knew, that it'll be set for hearing in the future. And if the state meets their burden, that is, the state's attorney's office has an evidentiary burden. They must meet the burden called a preponderance of the evidence. And just to define that term, and I do this for the people that come into my courtroom, that simply means that the evidence is sufficient to determine it's more likely than not. That's really the standard of a preponderance, more likely than not. I don't use the term probably, because that gets mixed up with probable cause. I don't want them thinking it's the same thing. So more likely than not, you may have heard, anybody who's watched television and any cop show or any crime show or the news knows the term beyond a reasonable doubt. So the standard in a criminal matter is beyond a reasonable doubt. Well, our standard is not that high. Our standard is a preponderance. And if I find, and there's no jury trial in juvenile court, so I am the trier of fact. So I must determine if the state has met their burden of a preponderance of the evidence. If I find that the state has met their burden by a preponderance of the evidence, this is what I'm explaining to them, then the case moves to a part 2. So they've met their burden. That means I would enter an order of what we call an order of adjudication and adjudicate the minor as a neglected minor. And then I must hold another hearing, a second hearing. The second hearing is to determine whether a parent is currently fit, willing, and able to properly protect, train, discipline, and educate the child. Generally, fitness. Willingness is usually not an issue, although sometimes it is. So if I find that a parent is unfit or unwilling or unable to properly protect, train, discipline, or educate their child or children. Then I can place the children in the custody, actually the guardianship of the Department of Children and Family Services. So I explain this. Now I have to backtrack here just slightly. This is what I'm explaining at the shelter care hearing. At the shelter care hearing itself, I merely have to answer 3 questions. The 3 questions, and this is what I pose to the parents. The 3 questions I have to answer at the shelter care hearing are, is there probable cause, which I define as some evidence that indicates that an allegation in the petition before me is correct? Some evidence, I stress, not a preponderance of the evidence. We're not declaring the child a neglected minor at the shelter care hearing. Shelter care hearing is just to stabilize the situation with protective orders and move on with the case. So some evidence I must find. Number 2, I must find, was it in fact of urgent and immediate necessity? Did the department make the correct call, in my view? I may find after the case is flushed out that there really wasn't urgent immediate necessity. I may return the children to the parents at that stage. However, if I do find that there's urgent and immediate necessity to remove the children for their safety, then I make that finding. And the third finding I must make, the third question we have to answer is, were reasonable efforts made by the department to avoid the necessity of protective custody? So for example, sometimes when a DCFS becomes involved, rather than take immediate protective custody, they create a safety plan, what they call, or what is called typically a safety plan, meaning, okay, you're going to live with the child and move into your mother's house, the grandmother, because the grandmother has a stable environment. And as long as you live there, and then there'll be no contact with a paramour that has committed domestic violence or whatever protective orders we do. And sometimes the department initiates this plan that is designed to keep the child safe, and a parent violates that plan. So in it comes for a shelter care hearing. They violated the safety plan to keep the child safe, so the department then has taken protective custody. Well, as far as reasonable efforts, I will find that they've made reasonable efforts because they didn't take the child immediately. They tried a safety plan where it was appropriate. Those are the efforts that they made, and it didn't work out. So I make my 3 findings and I enter an order granting the department temporary custody. So these children are in the temporary custody of the Department of Children and Family Services until the petition that was filed can be adjudicated. And we go through, as I said, the adjudication process. And then we go through the disposition hearing, part 2 that I discussed. And of course, if the findings merit, then the department is vested with guardianship. They become the actual guardians of the children. At all stages of these proceedings, a parent is entitled to counsel. Now I explained to them, you certainly have the right to hire an attorney to assist you during this procedure, but that's not easy. It's not easy to walk into a lawyer's office and say, can you take my juvenile case? And they say, well, I need $3,000. And not a lot of people have $3,000 hanging around. So a few questions are asked. Are you employed? Well, how much do you earn? Well, do you have sufficient funds to hire an attorney? And if the answer is no, I have 2 attorneys that are assigned to my courtroom from the public defender's office. Judge Buell has 2 as well. And one will be assigned or appointed to represent a mom. The other will represent a dad. And sometimes, not pretty often, actually, we have 2, 3, 4 children, and we have 2, 3, or 4 fathers for each of those children. So then I have, thanks to generous members of the Bar Association, I have a sort of bank of attorneys that are well qualified to practice in juvenile court, and I will assign private counsel to the third parent and the fourth parent, and sometimes the fifth parent. And everyone will have an attorney. The private attorneys are paid by the county when they file a petition for their attorney's fees. They have to keep track of their time, and the county pays them at a certain rate per hour. But everyone, we have very, very few cases. Occasionally, someone will say, I want to represent myself, which they have a right to do. But I encourage them not to exercise that right. You know, you may have heard the old saying, a person that represents themselves in court has a fool for a client. This is complex litigation. The rules of evidence are complex. The rules of procedure are complex. And the average person is simply not qualified to do that. And so if they choose to represent themselves, and they have a right to do so, I want to make sure they understand that they have a difficult road ahead of them, and I have to hold them to the same standard that I hold attorneys to as far as the admissibility of evidence. So if they have a document they wish to enter into evidence and it's not admissible, meaning if an attorney was tendering it, I wouldn't admit it, then I wouldn't admit it for them either. I don't get to cut them slack because they're not attorneys. So hopefully everyone involved will be represented by counsel, and we'll go through the adjudication and the dispositional hearing and conclude those matters. Let me make sure, I'm going to look at my notes to make sure I didn't forget anything. Okay. So the going back again to the shelter care hearing, we answer those 3 questions. We've placed temporary guardianship with the Department of Children and Family Services. I've made my findings, and the hearing is over. Now I have to give out dates for the future, and typically I give out 2 dates. The first date I give out is approximately 60 days away, and that's called a pre-trial conference. Pre-trial conference is simply a date for the parties to return to court and for the attorneys to exchange information that they intend on admitting in court, you know, the evidence that they have. Oh, excuse me. Forgot to turn my phone off. So in any event, we hold a pretrial conference. That's just, again, to exchange information, perhaps advise the court if there's anything unusual going on that needs the court's attention. And the second date I give is the actual hearing date for the petition, where the state must prove their case if they can. So, and typically, and per the statute, if protective custody is with the department and temporary guardianship is with the department, that adjudication hearing has to be held within 90 days of protective custody being taken. And unless there's a waiver by the parties, sometimes the parents themselves will request a waiver and to go farther because they're putting together their case or they're gathering relevant information for their hearing. And so I can be a little more generous than that 90 days if they need further time than that. But generally speaking, the adjudication hearing will be held within 90 days of taking protective custody. And at that adjudication hearing, typically that's set. I usually budget an hour to 2 hours, depending if we need that time. Most cases actually resolve themselves. The parents and the attorneys, the prosecutor, and the guardian ad litem will discuss the matter. We'll call the case. I'll let them talk for a few minutes to see if they're on the same page. And much like in criminal court, where 90% of the cases plea, probably more than 90% of our cases at the adjudication phase are resolved by agreement. The parents agree that at this point that they are not fit, willing, or able. By this time, they've already been assigned a caseworker by DCFS. So by the time we get to the adjudication, they have a caseworker working for them from either DCFS or one of its contracting agencies, Lutheran Social Services, Bright Point, which used to be the Children's Home and Aid Society, Camelot Care, or any number of other agencies. Those are the three main agencies that are here in Rockford. There's also sometimes children are located in Chicago, and there's an agency out of Chicago or some other part of the state that's involved. But in any event, if the parties agree that the state has sufficient evidence to prove by a preponderance of the evidence that the children were in fact neglected or abused minors under that Juvenile Court Act, then we can discuss disposition. Do they agree that there's an issue of fitness or willingness or ability? Oftentimes, the parties will agree to adjudication and ask the court to set a separate hearing for disposition. If I do that, that hearing will be within 30 days, not 90, 30 days of the adjudication. So we come in, parties gather, they've reached an agreement, the adjudication order will enter. They ask for a dispositional hearing, and I will set the hearing within 30 days of that adjudication. And then we'll come in for a disposition. Oftentimes, the attorneys or the parents will ask for that dispositional hearing to buy a little bit more time to get further along in services. It may or may not make a difference at disposition. Usually it doesn't, because 30 days, these are long-term type cases. But we set a disposition hearing, the parties come back, and we may have a hearing on that question of fitness, or they may agree at this point they're still not quite fit, willing, and able. The attorneys explaining really what they need to do to achieve fitness. So let me, let's see. I'm getting messages while I'm talking. It's very distracting. So in any event, I've been talking for another bunch of time. Does anyone have any questions? Oops, joke from another meeting. That's funny. Does anyone have any questions of, I've been just kind of free flowing here, taking you down this road that's a typical juvenile court case. I don't see any questions, so I'll just keep going.
I don't see anything, Judge.
Pardon me?
I said, I don't see anything, Judge. I haven't received anything either.
Nope, we're all good. All right, that means I'm excellent at conveying this information. Let me just leave that with you for a minute. In any event, so we've gone now to adjudication and disposition. A caseworker has been assigned to the family. The court has found the minor is a neglected minor or an abused minor. The court has found that parents are unfit or unwilling or unable. Now, where do we go from here? After disposition, the court must set a series of reviews that are 6 months apart. Okay, so what I try to do is, well, now I'll backtrack a little bit more. While this is all going on in court, behind the scenes, the department is putting together information to create a service plan that will be an outline of the treatment necessary for these parents to reunify with their children. So the department has to draft what we call a family service plan that has all the tasks that all the tasks that are assigned to the parents. The parents will be referred to domestic violence cases. The parents will be referred to individual counseling. The parents will be referred to substance abuse treatment and be submit to drug tests periodically. You know, all these tasks that they must complete and must do in order to make progress toward reunification. So generally, I will set the first permanency review after a disposition to coincide roughly with the first family service plan. Sometimes I can go out a full 6 months. Sometimes the first permanency review to be on cycle, and what we call on cycle, that means to be linked up with the actual service plan that's created. The permanency review might only be 3 or 4 months away, the first one. So the department, while I'm conducting court, the department at the same time is having semi-annual case reviews. They're called ACRs because it stands for Administrative Case Reviews. So we try to set our permanency review right after the next ACR. So when it comes to court, the department has already sat down with the parents and rated them on each of these tasks, that information, those ratings are the ratings that I have to examine, and I have to make decisions if the parents have made reasonable efforts and reasonable progress to correct the conditions that led to the removal of the children. So I'm quoting out of the statute. So if the children are placed with the department, then I advise at the end of the case, I have to advise the parents of this. And if they haven't been advised already, but I always do, you must now make reasonable efforts, which I define as engaging in the services that are prescribed, and reasonable progress, which is eliminating or minimizing or diminishing those factors that led to the removal of the child. Parents must make efforts and progress. So let's say efforts in a substance abuse case, you'll be referred, you'll go to treatment. You go to outpatient treatment, you might go in inpatient, then continuing care. You do what you're supposed to do. So that could be reasonable efforts. You're doing what you're supposed to do. However, you've also relapsed like 6 different times. And relapse, of course, is part of recovery, but at some point, continuous relapses means there's no recovery. So I may find you haven't made reasonable progress as of yet. You're working, but you're not conquering that addiction or for whatever reason. It is. If it's domestic violence, and then we come to the review period and we see, the state's attorney has 3 sets of police reports for 3 different domestic violence incidents. We've got issues. We've got progress issues, even if you're going to all your group therapy or doing whatever you're supposed to do, because the law says you must make reasonable efforts and reasonable progress to reunify. After a reasonable period of time, I tell the parents, after a reasonable period of time, if you have not made reasonable efforts and reasonable progress, the state has the authority to file a petition that requests of the court to terminate your parental rights. And we take that very seriously because I've used the phrase in court, the termination of parental rights, that's the death penalty for a parent. That's the death penalty of your parental rights. And I use that term because if a petition to terminate your parental rights is granted, you are no longer the parents. You are basically legally just another person walking the earth to that child. So that's a very serious consequence. If parents fail to make those efforts and progress, which does happen, then the state may file a petition to terminate their parental rights. If they do that, they have to allege specific causes of unfitness or specific types of unfitness. The unfitness allegations in a petition to terminate parental rights are not contained in the Juvenile Court Act, which I've been talking about. They're contained in the Adoption Act of the Illinois compiled statutes, which is chapter 750 instead of 705. So in any event, the state may file a petition. The allegations could be that the parents have failed to make reasonable efforts, count one. The parents have failed to make reasonable progress, count two. And they must allege, the Adoption Act says you must make reasonable efforts and reasonable progress during any 9-month period after adjudication. Sometimes the state, sometimes parents are just on the border, like they've made efforts but not progress, and then they come back 6 months later and they've made some progress, but then 6 months later they haven't made progress. At some point, I must find that they're not making sufficient progress. The case cannot go on forever. So the state can, once I find that they have not made reasonable efforts and reasonable progress, I can change what we call change the goal. Every case has a goal, and it almost always, occasionally there's an exception, but 99.9% of the time, every case starts with the goal of return home. Every child has a right to be reunited with their parent if it can be done so under safe conditions. So the goal is return home. Parents must make reasonable efforts and progress. If they fail to do so, the state has the authority to file this petition requesting that the court terminate their parental rights. Now, once that petition's filed, we have another arraignment. The parents are entitled to the same rights. They have the right to counsel, so their attorneys stay their counsel. The state has a higher burden. Remember what I said, the burden to find a child neglected is a preponderance of the evidence? Well, the standard to find a parent unfit for the purpose of termination is clear and convincing. That's a significantly higher standard. It's not quite beyond a reasonable doubt, but it's a more significant standard because the stakes are much higher. As I said, I always call a termination basically the death penalty of parental rights. So it's a higher standard, a higher burden. If at a hearing, and those are typically hearings, parents do have the right in the face of a hearing, if they understand that, look, they really have failed, they have the right to sign what's called a specific consent to adopt, meaning they are aware of the foster parents, they may be relatives, or they may have developed a relationship with the foster parents. And they may say, instead of going through this hearing, I'm just going to say that these foster parents may adopt my child. It's a very courageous decision if they make that decision. It's a very courageous and an unselfish decision. It's a very emotional decision. But many times a parent will make that decision. Other times, and I can understand this, a parent won't make that decision because they do not want to lose their parental rights. They will fight for their children, no matter how dire their case is. And they have every right. Everybody has their right to their day in court. But if the state meets their burden of clear and convincing evidence, and I find that they have not made reasonable efforts. There's going to be a question. Let me finish my thought, and I'm going to get to this question from Miss Knight. Give me 1 second. If I find that the parent has not made reasonable efforts, therefore they're unfit, I don't have to, if there's 3 or 4 allegations in the petition, I only have to find one to find them unfit. If I find them unfit, again, we go to another part 2. And part 2 is called a best interest hearing. Now I have to decide, now that the parents are unfit, is it in the best interest of this child to terminate parental rights? And there's a number of factors that are contained statutorily, but generally speaking, I have to assess if reunification is possible given the track record. If I find that reunification, the prospect of it is dire or poor, I may find that it is in the best interest of this child to be freed for adoption by termination of parental rights. That's not an easy decision, but it's a decision that has to be made one way or the other. There's a question here. Let me see. If a survivor of domestic violence is engaging in police contact, as in just calling the police for an offender stalking them or violating OP, but has engaged in reasonable efforts in filing the OP and in finding alternative housing, what is recommended as an additional step for them to take for their and their children's safety? Well, first of all, when I mentioned the police reports and the domestic violence, clearly, if the reports indicate that the survivor is in fact a victim of the harassment, stalking, violence, unsolicited, that is not going to be held against that survivor. That is not going to result in a no reasonable efforts or finding. If this, we have cases where we have to grant orders of protection in cases because the survivor is not left alone by the offender. What steps can they take outside of the order of protection? The only steps, I mean, the order of protection is this most significant step. Hopefully they have not, as a result of any cajoling, invited the offender into their household. They haven't let their guard down. But what they need to do in our courtroom is keep their guard up, keep vigilant, stay in touch with their caseworker, make sure their caseworker, especially if the offender is another party, it's the father of the child. So the caseworker knows that this other person is not doing what they're supposed to do and can bring that to the court's attention. If the perpetrator violates, well, if they violated an order of protection, they're going to get arrested. But even if there's no order of protection, but a no contact order, I may find that perpetrator in contempt of court and sanction that perpetrator in that way. But actually, the steps that are stated in this question are exactly the steps that you need to do. You're at home, this person, you have an OP against a paramour or the father. He shows up banging on your door, you call the police. That's what the question said. That's exactly what that person should have done. And if you don't have an OP, the next day you come and get an OP. So the next time that happens, if it happens again, that person will get arrested for violating the OP. And I tell, this happens all the time. And so I make sure that the survivor knows that I'm ordering, for example, an emergency OP. So that means we have to serve the perpetrator. And I advise them, listen, if he shows up at your door, do not answer the door, call the police immediately. If the police arrive and he's still there, they'll serve him on the spot with the OP and send him on his way, because he's not violating the OP if he hasn't been served. Then if he comes back again, he's going to get arrested. Or if he has been served and he shows up and bangs on your door, he's going to get arrested if he's there. And if he's not there, the police will make a report and they'll probably come to me for an arrest warrant for violating the OP. So that is the standard. I hope I've answered that question to your satisfaction. It is 12:57. I don't know if there's much more to say. Once I terminate parental rights, generally speaking, the goal for the child is adoption. The foster parents have already committed to adoption, and then the paperwork has to get done. It's called a subsidy. Has to be cleared by the Department of Children and Family Services. The foster parents retain counsel, which is paid for by the department if it's a department adoption. And I usually conduct adoptions Monday through Friday at 8:30. You know, the attorney just gets to me. So Nikki, I think I'm done. At 12:57, I think I timed it maybe just right.
Yeah, impressive. Thank you. I just put the link to the eval in the chat. I also want to use this as an opportunity to highlight that the court released season 2 of a podcast not too long ago, all about juvenile abuse and neglect court. And if you're interested in learning more about it, Judge Martinez and Judge Buell, who also presides over JA Court, have their own episode where they talk about these things with an interviewer. And there's many, many, many other episodes that involve juvenile court too. So if you hang on just a second, I can throw that link in the chat. And Judge, we can use this as an opportunity for you to kind of close up and see if there's any questions while I track that down.
Sure. Does anyone have any questions on what we chatted about? I know it's very complex. Most of what I've talked about, you can compartmentalize, and I can do an hour on shelter care, so I can do an hour on adjudications alone. So this has really been a very general survey. So we tried to hit the key points. But if you have any questions, or feel free to send me an email at fmartinez@17thcircuit.illinoiscourts.gov. I'll be happy to talk about juvenile court in general, not specific cases, of course, but juvenile court in general. I'm always willing to talk to anybody that wants to listen. Good.
Yeah. Okay, well, with that, people are obviously free to go. We're not going to keep you, but complete your emails, check out our podcasts. Oh, Judge,
Oh, I
someone
will
does have a
answer. I'm going to answer
Yeah.
one question. It says,
Question.
what do
Here
you
we go.
do for self-care handling tough cases? I listen to the Grateful Dead. I take a trip with Jerry Garcia, give me a Grateful Dead show, and I'm all good again, and drink a cup of coffee. It's all good.
Yeah, if you've ever been in Judge Martinez chambers, it's very lots of concert posters and stuff in there, huh?
Bet.
Yeah.
All right. Well, thank you, everyone.
Thank you.
Thank you very much. I will leave the session. Good luck to everybody. Have a great Friday.
Thank you.
Bye.
Bye.